activated? Or?
No, I feel like it's activated right now. I think you press it probably to.
You press it and it becomes green, and then you talk. Otherwise, you're muted.
So green is on.
Yes. Do we need to wait for the court reporter?
Apparently, the court reporter is virtual. They're listening in even as we speak.
Oh, I'm sorry. Were we just waiting for us to chit chat? I thought we were waiting for something else. I'm so sorry.
I didn't want to interrupt.
Oh,
Good morning. We're here for the resumption of the hearing of the Disability Rights Coalition in the province of Nova Scotia and the Nova Scotia Human Rights Commission, which has been ongoing and under one heading or another since 2018. On the 25th of April, I received an email from Mr. Kindred representing the province on behalf of all the parties. And I'm going to read that into the record. Chair Murray, I am writing further to my March 1st, 2023 email update, again jointly with the Nshrc and the Nshrc, to provide another update. As of today, we have agreed to an interim settlement agreement based around implementing the recommendations of the expert report that was provided to you in March. In broad strokes, the agreement sets out a 5-year process towards achieving the final outcomes recommended by the experts, be consistent with the Court of Appeal decision. The detailed work year by year is set out in several appendices to the interim settlement agreement. It also includes a process for monitoring progress periodically throughout the 5 years and an enforcement process in the event of non-compliance. It is particularly important to the parties that there be ongoing monitoring in a transparent way as a means of assuring all stakeholders and the general public that the commitment to human rights compliant reforms is real and tangible. We are describing the agreement as interim because the matter will not be fully resolved until the 5-year process, including final outcomes, is complete. We have also drafted a proposed interim consent order to which all parties are prepared to consent. We will provide signed copies in due course. Given that there is agreement among all parties, it appears to fit under Section 34 sub 5 of the Act, referring to the Human Rights Act. However, we recognize that this is an unusually complicated settlement. It may be that the next steps can be resolved without a hearing. However, if a hearing would be beneficial, the parties have availability as early as June. We also want to let you know that because there is a public interest in the matter, we plan to make the expert report available publicly later this week, likely tomorrow. The parties will confirm publicly their intention to use the report as the basis for the remedy, while recognizing that the final steps to confirm the remedy are with the Board of Inquiry. We welcome your thoughts and directions as to the next steps from here. It was because of Mr. Kindred, on behalf of the parties, references to the public interest and the complexity of both the technical report, its recommendations, and the so-called interim consent order that I received on the 27th of 2023, that I felt it important that there be a public airing of what the settlement actually was, what it contemplated, because it does represent a significant change in approach to how the province fulfills its obligation to the disabled community. And there's going to be an iterative process contemplated for the next 5 years. And so I thought it would, in the public interest, that there be a public explanation by the parties as to what's contemplated, why it's going to take 5 years, and what are the steps generally, not necessarily specific, but generally, what are the steps contemplated going forward over the next period of time. I noted myself reading the technical report that was then provided for review, that in fact the technical report even anticipates another 5-year period after the initial 5-year period for further work, recognizing that what the work that's going to get done is going to be an ongoing process, and there'll be things that perhaps will be easy, things that will be less easy over the course of time, and there are also some issues with respect to the independent funding model or individual funding model that doesn't address questions that are addressed in the technical report, such as the sufficiency and adequacy of funding, which is a whole other separate issue that I'm sure the parties have turned their minds to and chosen not to speak of in the interim settlement agreement. In addition to all of that, I raised with Mr. Kindred in response to the parties and to the rest of the parties what the proper role of the Commission Board of Inquiry is going forward from this date. As the parties well know from decided cases and the legislation under Section 34(5) of the Human Rights Act, it's my role to report a settlement, not to comment on the, well, I'm allowed to make comment, but it's not my role to prevent an agreement. And it's not my role to, therefore, to comment on the wisdom or value, in my view, of the settlement and the choices made by the parties. But that's still something that I expect the public is interested in knowing. And so while I won't be commenting on it, I am hoping that today in this forum, which is a public forum, the parties will feel able to comment on the merits and benefits of resolving the matter in the way that they have chosen to do so. The last thing we need to deal with today is whether, in fact, the so-called interim settlement is in fact an interim settlement or a final settlement, and whether it's appropriate for this Board of Inquiry to accept a continuing role with respect to carrying out the terms of the settlement. And that's was particular interest to me as I read through the settlement agreement and the technical report. The Board of Inquiry kind of got thrown in year 4. They didn't get thrown in as an annual review, and that may have been a mistake in how they set out the parameters for each year's step in the process. But I don't take any offense from this. The Board of Inquiry really is the fifth wheel when you look at the detail that's been provided for the internal government assessment and evaluation of how the settlement is working over the course of time. So having read through all the materials, having read much of the evidence of the original hearing, I can see how the interim settlement agreement speaks to a number of the issues that arose during the course of the hearing that was heard initially. But I'm struggling with whether the Board of Inquiry really has an appropriate role beyond today. The expert monitor, as contemplated in the settlement agreement, strikes me as a more expert way to monitor progress and deal with progress. And having the Board of Inquiry continue to exist because maybe there might be a problem in the future is going to take some convincing for me as to why this should continue. So with those initial thoughts, I don't know, because it's an agreement among the parties, who wants to take the lead in terms of presenting what we have. And I know the Commission took a role during this process of stepping back and allowing the direct parties to work through the nuts and bolts issues. They were kept informed, but they weren't actively involved at each step of the process. So I'm not expecting Mr. Douglas to stand up and say, I'll jump in and start first. But between Ms. McNeil, Mr. Calderhead, Mr. Kindred.
Yeah, well, we had a discussion about this yesterday and agreed that I could start off with some opening comments that would cover a little bit of sort of the how we got here, an overview of the agreement. I will say in that too, I kind of focus a little bit and maybe unduly on the mechanics of the agreement as opposed to the substance, but I will try to walk through on high level, the substance of what the agreement, what changes the agreement is going to see, although I feel like just could give you that kind of page and verse, but I'll do a bit of a walkthrough of that too. And then hone in on the questions that you had, which I would say are sort of jurisdictional questions about role of the board and that sort of thing. And you had articulated some of those specifically, and we can do that. So first of all, just a little bit of how we got here, recognizing nobody here probably needs to be reminded of this, but it's on the record, and we'll just
and the public is listening, so.
Yes, exactly. And so, this is getting close to the final step arising from a complaint that was first made in 2014. There was a finding by the Court of Appeal in 2021 of systemic discrimination, which is the portion of the complaint that we're now actively still dealing with. After that finding, we went through some further hearings to clarify that finding. The province had Section 6 of the Act allows the province to raise potential justifications. We did have some time to sort of explore the province's concerns under that, and sort of by consensus agreed that those were better dealt with as factors affecting the remedy than needing to be raised as Section 6 arguments, and so our focus shifted to the remedy. And you'll recall we had dates scheduled in October and November of 2022, quite a lot of time scheduled on the understanding when we scheduled them that we might have a lot of detail that we needed you to, a lot of evidence that we needed you to hear, and a lot of explaining different views as to what a remedy should be in a traditional hearing fashion. We then had, I think, between the parties, productive discussions about what the most efficient way of remedying the issue really would be. And that really was from a starting place of, despite having some legal agreements as to the definition of discrimination, which is what took us to the Court of Appeal, we did all along have some mutual understanding of what reforms needed to be made to the system. Perhaps not complete seeing eye to eye on it, but both parties approached this with an understanding that reforms to the system were necessary. And so we weren't starting from zero in terms of focusing on a remedy. And in discussions with the DRC, the province, I think it was the DRC's proposal, and the province was convinced that a better approach, rather than hashing it out in a hearing form, was to engage an expert who both parties could turn to for advice, an expert report on the changes that should be made to the system. And so with that idea in mind, we sought an adjournment of those dates that were scheduled, and you agreed to that. I think you agreed that it made sense in terms of the efficiency of getting to a remedy to allow the parties to take that approach. And so we engaged experts. There was an Australian expert and a Canadian expert who worked in conjunction to produce the technical report. They worked on a timeline that was aggressive but realistic. They spent a lot of time with stakeholders, both from government and from community, from advocacy organizations, in order to fully understand what the obstacles were and what kind of reforms, in light of changes that had been made across the world to similar programs, what kind of reforms really would best speak to a human rights compliant future system. And those experts were knowledgeable both about the needs of the community and also about the operations of government systems. And so we're able to, both sides trusted the advice that we got from them collectively in the form of the technical report that you referred to.
And I'll say more program level advice that the discussions that choose
Yeah, and maybe just to take that and put that in context.
No, that's not part of the consent.
Well, and we knew for what we wanted the experts to do was give us truly their best advice without necessarily talking about what we thought was within jurisdiction and those sorts of things. And so we welcome them to make comments on governance structure, but we also, as we ultimately agreed in the consent order, things that have to do with government structure or changes to legislation, we don't consider to be part of the remedy. That's for jurisdictional reasons. But we do welcome that advice, and the government will continue to take that advice seriously as well. Another thing I'll just say about the way that we engaged with the experts, because you commented on them mentioning the Board of Inquiry. We also really, the experts were aware of the legal process going on, but we really wanted them to not be concerned about giving us sort of a guidance through the legal structure of implementing a remedy, to really focus on the sort of technical aspects of the change and to use their expertise. And so, there may have been a throwaway reference to the Board of Inquiry. We didn't spend a lot of time trying to get them to walk us through the legal aspects of it. And so that I lost track of that reference to the Board of Inquiry in year 4, but we've taken in the interim settlement agreement what we think is the guidance and direction in the appendices of what year after year need to be changed. And so we thank the experts for their advice. You'll see that the agreement is largely based on their advice. There's some aspects that we left out just for jurisdictional reasons, or because they weren't really getting to the core of what we were looking for.
I do appreciate you have to state that you use your agreement, settlement agreement, and just state
right. Yeah, it was a lot more work than that, as it turns out. So that's where we are. We got the technical report in February, and we sort of knew that we wouldn't just be able to staple it to something and call it an interim agreement. And so a lot of work went from both sides into assessing what of that needed to be part of an order for government to implement, and also what kind of structure that should work within. One of the struggles that we mutually knew that we would have is this would have to be rolled out over a long period of time. And the experts were not realistically going to predict that, in July 2027, XYZ is going to happen. We appreciated them giving us a guideline, but we knew that there might be parts of what they recommended that we modified on the way, whether we modified a date to make it more realistic, or we found a different way of accomplishing the same goal. And so a lot of our discussions were on how to have an order that was binding on government to achieve the outcomes largely in the way contemplated by the experts, but still allowed the kind of realistic flexibility that we weren't here arguing about a violation of the order because a deadline got moved by a month, or we found a better way of doing what the experts told us. And so a lot of the hard work between the parties really was structuring the agreement to make it both binding and clear, and also flexible enough to reflect the reality of what the next 5 years are going to look like.
And just while you're on that, one thing that struck me as I was reading through the materials, and maybe I missed it, I didn't know where they were getting the projections for demand for services in year 5 and year 6 and year 7. I don't know if those exist. They probably do, but I didn't see them or notice them in the materials.
Yeah, so in fact, part of their, and now we're getting into a level of detail where I'm going to look and see if Maria gives me a glance and I'm getting it wrong. But the part of what they recommended to us is acknowledging that we needed to be better able to predict what need for services was in the future. So in response to their recommendations, we have also done work on trying to effectively model that, knowing that there's no world of perfection in terms of modeling future outcomes. But so, part of what we needed to do was put the work into knowing what the future of needs would be. And so I feel like we feel confident that we've done some hard work in getting those models. It may still be a work in progress to some extent, but that's sort of part of the early parts of the recommendation, is to work on our ability to assess what the program needs for the future.
Yeah.
So in terms of how we got, and before I leave how we got here, I'd be remiss not to just say this in recognition of the hard work. It did really represent, I feel like there was a moment where we truly shifted from maybe, as professionals, we never really want to be completely it's an adversarial process that we engage in. And sometimes it takes a lot for us to abandon that adversarial approach and truly be collaborative. But I feel like between the parties, we accomplish that with a lot of hard work and disagreements along the way, as you would expect in any negotiation. But I do want to sort of recognize too the hard work that my friends from the DRC have put into that collaborative approach alongside the province as well.
And including all the people that participated in those meetings with the technical experts.
Oh, absolutely, yeah, and it's to the experts' credit how much of that they were able to do in an abbreviated time frame, and a lot of that was because they had the expertise, knowledge of both the needs of the community and the workings of governments broadly to hit the ground running in those consultations. So that's sort of how we got here. The next thing I want to do is just walk through the agreement a little bit. As you read, my email kind of describes a bit of an overview of it, but I have it in front of me, and I think I'm just kind of walk through again, mostly for the, I know that you've read it, mostly for the sake of getting it on the record, what the agreement actually, how it works. And so we have, it starts with an interim consent order. Again, we'll answer some questions about the jurisdictions about these, but this is what we've structured. An interim consent order that sets out a lot of the background. The operative parts of the consent order really are just ordering the parties to follow the settlement agreement that they've adopted, and ordering that the Board of Inquiry has continuing jurisdiction to adjudicate any issues that arise. So obviously we'll talk about the reasons for that, but that's the content of the order itself is pretty slim. The details are really in the settlement agreement. Broadly speaking, the way that the settlement agreement works is if we put a detailed 5-year plan in place following the recommendations of the experts, the sort of year-by-year content, I guess the to-do list, if for lack of any better term, is in appendices to the agreement. So each year of that plan has an appendix outlining the work that the province is to do during that year, recognizing that there may be flexibilities as to how we reach those goals, and we'll talk about that in a moment. Before moving on from the concept of 5 years, I want to note it is a 5-year plan. So just how we get to 5 years. They did make recommendations that started from February to June, as you noted in your email response. And so the province has, I don't want to say voluntarily, but I guess before, the province has agreed to work on those recommendations before this agreement becomes effective. That work continues to be underway. Yep. And so really the start date for the agreement is July 1st, 2023, despite there being recommendations that predate that, but that's sort of how that comes together. And also the end date of the agreement, we structured the years of the agreement to cover government fiscal years. That's the way that it made most sense to report. So the end date of the agreement is actually March 31st, 2028. So that's not calendar 5 years, but it's still correct to call it a 5-year agreement. Mm-hmm. So we have some general concepts set out at the front of the agreement. We set out our own summary of the violations that were found, while recognizing that legally it's the court and your interpretations of the court's decision that truly contain the findings of violation. But for the purposes of the agreement, it was useful to summarize them. At this point, I'll pick up on something that you noted too. This will be a system that will always be under reform. Like I think the experts recognize that there will be progress to be made after the 5-year system, and we don't want to create the impression that this is, once we reach the end of 5 years, the system's never going to be touched and it's going to be perfect. What we wanted was goals to remedy the specific findings of discrimination that were at issue in this case. So, for example, the issue of amount of funds wasn't directly dealt with by the Court of Appeal. That's not to say that there won't be a problem that'll be encountered, that there won't be developments in that area, but the agreement isn't structured really around dollar amounts because that wasn't the finding of discrimination to remedy. So there will be other kinds of work that have to happen to the system that are outside the scope of this, and forever there will be calls to reform, make changes to the system. We're trying to get to a place where the specific findings that have been identified by the Court of Appeal have been remedied.
Because governments change, and even health policy as to how best to deal with the disabled community, that will change too.
Of course, and in 50 years, we may be operating in a whole new world with different theories as to what government should be doing in this area. We've sort of got to recognize that too. So it's the 5 years is not the end state of the system necessarily, but it ought to be the end state of what's required to remedy the specific findings of discrimination in the Court of Appeal.
What if we looked at it though as this agreement resolves this particular piece of litigation with a 5-year plan as to this is the work we're now going to do, and then that work's going to continue, and it gets a life of its own. Okay, that's really because there's parts of the technical report that really go beyond what the finding of discrimination was and what the actual remedy, if you wanted to be very narrowly focused about it. One of the things that I noted about the technical, it was very forward-looking, and the idea of how to resolve all of these issues was a broad blue sky view was taken, and so it's really more of a launching pad than are you going to meet the terms of the settlement? Is what the real objective of the whole plan seems to be.
I think that's fair. And as one thing that we observed as we go is as we get closer to year 5, the goals become a bit less sort of specific because there's a lot more. I don't want to say unknowns, but the goals are a lot broader as we get later into the into the 5-year period. I will say that the experts report reflected a few practical principles, one of which is that there are a lot of interlocking pieces. So it's broken down into sort of specific areas of recommendation, but there's a really heavy recognition that it's that the reforms need to be sort of holistic. And so, for example, the remedy is not as simple as closing institutions. Government could close institutions and provide no other supports and make things a whole lot worse. And so closing institutions doesn't make sense without working on the wraparound services that actually facilitate people living in community. That doesn't work well unless we change the model of how support is provided from something that's less finding a place and more empowering someone to make choices through a funding model. And so these are all interwoven pieces, none of which can get too far out ahead of the other, or else some part of it will fall down.
And you create new temporary needs. When you close institutions, you're destroying an environment that people have at least become familiar with. And if they've got an unfamiliar environment, they're very unstable for a period of time until they have a new normal.
Right, and so like some of the even just the closing institutions parts of the recommendations are not as simple as when to close doors on buildings. It's the work that needs to be done to find individual plans for truly individualized to the needs of each person who's in one of those facilities now, to prevent those kinds of poor transitions to living in community that otherwise might encounter if the supports weren't correctly done. And so again, complicated. It's also an explanation for why it does get rolled out over a long period of time, because moving too fast without other pieces in place could potentially cause more problems than it solves. And so the 5-year time frame is one that we respected. We recognize the need to move urgently with this. We recognize that there's been a long period of promises from government that have not been actualized to the the expectations of the community. And so we respect the time frame. It's equally important that that be in the form of a binding agreement so that it's no longer just government promises. It is an enforceable order against government that will force this work to be done. And so, and sorry, I've sort of wandered away from my
Well, I threw you off
my
track.
plan here. That's fine. Actually, I'm pretty flexible that way. But so what I was just sort of walking through the agreement and how it works.
Yeah.
I think section 5 is important because it's sort of where we describe the need for flexibility.
Mm-hmm.
So the outcomes at the end of the 5-year period are crucial. It's key that those have to be achieved by the province. The major milestones to get there are also crucial. But the closer we get to minutia, the more we need to recognize there may be other ways of getting specific thing XYZ done, or it might be done 3 months later than we originally intended. And so we wanted to find an agreement that both made it clear that the outcomes had to be achieved, but allowed that flexibility. And so we agreed that there were ways for the province to remedy discrimination. There were multiple ways for the province to remedy discrimination. It wasn't as clean as following a step-by-step color by numbers guide. And that there could be changes in circumstances along the way that required the path to be revisited, and the parties contemplated that. And so long as the province continues to be making substantial progress towards the outcomes, we're still complying with the agreement despite any kind of twists in the path on the way. And so we defined we defined terms like exact compliance, but also compliance in substance, where we haven't done exactly what we've set out, but we've achieved the underlying goal in a different way. Substantial progress, meaning we're continuing to be on track for the outcome, even if we have missed adjusted a deadline or changed a plan on the way. And ultimately then, concepts like outside the control of the province, which are really about the end state and what we've been able to accomplish. We agreed, I want to focus on the role of the expert monitor for a moment. So we agreed that it made sense for there to be, without needing to come to the Board of Inquiry to adjudicate issues, that we would have ongoing benefit from reporting to an expert who could comment on the progress that we've made. And particularly knowing that we've sort of built in some flexibility, we should also have to explain when we have veered from the path, why we did that, why we think we're still accomplishing the goals, and that it shouldn't just be trust us, that we should have the view of an expert who can comment on whether we've done the right thing by straying and what our path is to get back on course, or whether the new course is equally as good.
Do we know who that might be?
So what we have put January 2024 as the goal for choosing that person. We've set it up so that it will be an independent person under the auspices of the Human Rights Commission, but that the parties may select that person unless, and if they can't agree, then the commission may have to resolve that deadlock. So we know that the next piece of work is for us to hone in on finding that mutually agreeable expert. Luckily, we did a decent job at finding the experts already, so I have some confidence that we'll find someone, but we don't have a name for you now.
Well, and I wasn't necessarily looking for a name, just
okay.
Where are we on that, because that, as you say, the expert monitor has a fairly prominent and important role, because it's fairly specialized area of knowledge. Realistically, you'd want to have people in mind, I would expect now, to retain by January, because you're asking that person as well for a 5-year commitment. There's also the talk in the technical report about getting a consortium perhaps of academics who will continue to provide input, which is an interesting concept to me, when there's probably a lot of intellectual capacity in-house at the Department of Community Services, but that's the choice that the parties have made.
Yeah, and to speak to that for a moment too, so there are aspects, I mean, I won't get into the nitty gritty of all of the elements of the appendices in this, but there are aspects of the report that are about the evaluation and transparency as well. And so the expert monitor is not the only monitoring function that's kind of built in. Some of the work of the department will be to create review processes, and evaluation processes, recognizing, I think, that there is internal expertise of the department, but also that we sort of have an obligation to get outside the box of the inherited knowledge of the department, which may in and of itself inadvertently be influenced by years of a problematic system. And so we've sort of been recommended and are taking this seriously to build in external evaluations so that we don't get caught up in our own old ways of thinking and old ways of doing things. And so that's built into some of the work. The expert monitor is more in terms of monitoring compliance with the plan that we've set out. Okay. But other evaluations of the system by experts are kind of built in as well. And so the one thing that I'll say about the expert monitor is that we did try to be careful to make that a non-adjudicative role, just an expert in opinion, but no one, not someone who has an order-making power or anything that could be seen as a delegation of the Board of Inquiry's authority. We just wanted there to be an expert on whose advice we could rely in our own assessments of how we're doing and in the DRC's assessments as to whether the province seems to be making the right kind of progress on the plan.
Yeah, and deep into it, once we get to clause 18, there was some potentially problematic language about the authority of the monitor, but we may not need to get into that as deeply as I initially had thought. So
okay, fair. And I do, you had set out some specific questions, and sort of I'll turn to those specifics towards the tail end. I do have that issue in mind, but this is I'm more trying to just walk through the overall here.
And I was just picking up on your comment, non-adjudicative, because there are points at which your concept of the expert monitor was that the expert monitor would be making judgments about factual compliance and those kinds of things.
Yeah. I think I will pick up on that point, but I just want to hone in on the specific question that you asked and the portions of it that you highlighted in that question. So I will get to that just in the later in the structure here. And so the next part C sets out that monitoring in a bit more detail.
Before you get there, sorry.
Yeah.
I'm still back in part A at number 8, which actually talks about the Board of Inquiry being necessary.
Sure.
And I'm struggling with that.
Okay. Yeah. So I'll say a little bit about this, and then
come back to it.
I'll come back to, because you had asked a specific question about this. But I guess generally our approach to that is that we did see that there was the need for a Board of Inquiry to serve a potential adjudicative function as we go through this 5-year process. It's not the function of monitoring the agreement or sort of getting regular compliance reports or whatever that can happen between the parties with the involvement of the expert monitor. But this is not, this goes to whether this is an interim or a final agreement. The parties don't see this as a final disposition of the case. We've built in the path to the final disposition of the case in this agreement. We see that one of two things will ultimately be the final disposition of the case. Either there has been compliance with the agreement, in which case we come to the Board of Inquiry for a dispositive remedy that is just about the declaration, the declarative parts of the remedy, finding that there has been discrimination and that it has been remedied in accordance with the agreement. The other possibility that we have to contemplate is at the end of 5 years, the DRC is of the view that the province isn't in compliance with the agreement. And in that case, what we've built in is that we would come back to the board. Not necessarily just at the end of 5 years, but if at any point in the life of this 5 years, it is clear to the DRC, or it is the opinion of the DRC that the province is not going to be in compliance by the 5-year mark, then we can come to the board for a truly remedial order. What that looks like, it's hard to define in advance, but it may be get the province back on board for X, Y, Z. It might be that the province identifies some new issue that requires a different approach to be ordered by the board. If we're at the end of the 5 years, it might be that again, I'm anticipating remedies for problems that I don't know what exist yet, but there may be, if we're in that world where the argument is as to whether the province has truly done what was set out on an interim basis, then we would come to the Board of Inquiry looking for a final remedy that would be more specific orders, a specific remedial order from the Board of Inquiry. And so broadly speaking, that's why we see this as an interim, and why we see there's a necessity that there's continue to be a Board of Inquiry with jurisdiction, because at any point the DRC may feel the need to bring an application for a more final remedy because they would argue at that point that the province is not on track to be compliant, even by the end of the 5-year period. And so, I'll come back to the specific question, but like in broad strokes, that's why we see that there's a need for a retained jurisdiction of the Board of Inquiry, and why we see this truly as an interim and not a final disposition of the case.
Yeah, we'll talk about that.
Okay, okay. And so maybe I think I'll speed through my walkthrough a little bit, because there obviously are, the jurisdiction questions are what we need to get to. So we have a portion for monitoring. We have a portion for transparency, which is, we will be making annual progress reports. The DRC will be making annual comments on our progress reports. We will also be doing semi-annual disclosure of just the data parts of how we're doing on compliance. And so there's a lot of not just checking in at the end of 4 years, but a lot of being open with the DRC as to the progress that we're making in 6-month intervals. And there is transparency, in that we've also agreed that shouldn't just be between the parties, but that should be to some extent public. And so the Human Rights Commission, for its role in this, has agreed to host a spot on its website where all of these progress reports and some other materials will be posted, so that the public can also be informed as to the ongoing progress of compliance with the agreement. And we felt that transparency was important, because, as the board has noted, the public interest there's a public interest in the remedying of discrimination regardless, but the public interest in this case is particularly high given the number of people impacted.
Sure.
And then in compliance and enforcement is the final section that we've set out. And the basic concept there, again, you've read the agreement, but it comes back to this idea of substantial progress. So we have sort of defined what the jumping off point is to the board. And it's not, we have agreed that not every issue of not being strictly in compliance with the letter of the agreement is an issue that needs to come to the board. We've tried to define what the threshold is for issues that are serious enough that they might need to come to the board for a modification of the remedy or for some kind of new final remedy. And so we've tried to define what non-compliance is there in section 18. The alternative of that would be the province may seek a declaration of compliance if we reach the end of the 5 years, or if, to be optimistic, if we feel like we're in compliance before we've even reached the end of the plan, then the avenue is there for us to come to the board for our version of the final remedy, which would be a declaration of discrimination and also of compliance. And so those are sort of the two paths to a final disposition that we've set out here. And finally, we've just administratively, in furtherance of that, we've agreed that it makes sense to have an annual potential checkpoint with the Board of Inquiry. And so we've talked about an annual case management conference in October it will only need to happen if the parties identify a specific issue that needs to be brought to the board. Otherwise, we don't have to have the case management conference, but it is sort of a regular checkpoint for both parties to decide whether there is anything in the last year's experience that requires going to the board. We also agreed we can come to the Board of Inquiry at any time, but we felt like that annual checkpoint was part of the sort of way of staying on top of it and not letting the board be too out of the mix in terms of the progress that's being made. And so that's as I said, my overview is probably more about the mechanics of the agreement than the substance of the work being done. But the technical report is available to the public, and both parties have sort of talked about the key elements in their public communications about the report. But it does cover a path for closing institutions, having people who are currently residing in institutions, newly residing in community-based settings. We've really done analysis on what kind of community-based what community-based living might mean, and broken down the idea of there being a couple of cookie-cutter models of community-based placements. We're really evolving towards a system that's highly more individualized to specific needs. There still are programs and there are kinds of community-based settings that kind of exist and are structured, but with a much higher emphasis on individualization and not about and an emphasis away from slotting people into existing placements in the program. So breaking that way of thinking is a big part of the reforms that need to come up. Mm-hmm. Some of that comes along with another key component, which is individualized funding. And so really having the program work in a way that is about the funds that are available to the individual in order to, the funds and then the accompanying supports that are available to the individual in order to make the best choices as to how they should be living in community and the best supports that the province can provide for that. Mm-hmm. And then there's, as I said, elements of sort of monitoring and internal reform and evaluation that are built in there.
I can anticipate that being really complicated.
I think my colleague here would agree with you that it's very complicated. It's a massive piece of reform, and what I can say is that it's reform that the department has acknowledged the need of in some ways and been working on in some ways for some time. But the expert report, I think, shed light on some things that the province didn't realize the importance of, or some new ways of reforming that were based on sort of best practices worldwide, that wouldn't have been in the original plan. So even with sort of the institutional knowledge of the province, knowing that reforms need to happen and having a sense as to what those reforms look like, the expert report allowed us to see the depth and the complexity of it in new ways, but also the potential for new creative solutions that truly are breaking down old ways of doing things and setting things up for success in the future. But absolutely, it is complex.
Yeah, and the technical report provided that link as to how individualized funding is going to work, and I clicked on it, and I didn't feel very informed at all by the time I watched the little video about how individualized funding worked, because unless I know the amounts and the community in which I'm living and the services available, it doesn't help me.
Yeah, I think that's true. Again, the experts report and the finding of discrimination wasn't really honed in on dollar amounts. Similar, we have annual discussions as to what supports under social service programs look like, and I think that the report is focused on the way of structuring the spending of dollars by the province that allow individualized decisions to be made in concept, but it's not focused on telling us what those dollar amounts should be. That's a different part of the work of the department.
And then there's a whole other level of who's making the decisions about the money, and is it going to be a paternalistic thing? Is it going to be a family thing? Is it going to be, it's a capacity issue, because there's all the talk about the
Yeah, absolutely. And I think a lot of the report and a lot of the ongoing work will be about finding the ways of breaking down that paternalistic approach that frankly has been a feature of the history of this program, and empowering people and their networks of support to make the decisions best for them. Obviously, there are limits to the amount of support government gives in individual cases. Like, no one's pretending that there's going to be infinite money available to every applicant in the system. There are going to be limitations that we work within, but it's about shifting the power of the